Mr. McLeod, Pereira seems to work against you, so I think it would be good for you to spend a bit of time on that.
Certainly, Your Honor. So I think that the important thing about Pereira is that it was a narrow decision that decided a particular question presented, and that question presented was about the interaction between the stop time rule in 1229 BD1 and the notice to appear requirements. And if I could point to where in the court's opinion that holding appears, it's at the beginning of Part 2B of the opinion. This is on page 2114 of the Supreme Court reporter version, if you have that available. And at the beginning of the first paragraph of that section of the opinion, the court says, the statutory text alone is enough to resolve this case. It then proceeds to analyze the text of the two provisions that I just referenced. Now, it's true that after this point in the opinion, there is additional analysis, but I think much of that additional analysis is dicta. The court said that that analysis supported or bolstered or reinforced the conclusion it had already reached. And I think that's particularly true of the statements that the non-citizens and the Ninth Circuit have relied on in Pereira. To go directly to the statement about the meaning of change, the meaning of change was not briefed in Pereira, was not argued in Pereira, and so the court in Pereira did not have before it the wealth of argument and evidence that we have brought to bear on that question in this case.
I take the point, Mr. McLeod, but, you know, it is a very direct statement. By allowing for a change or postponement to a new time or place, Paragraph 2 presumes that the government has already served an NTA that specified a time and place as required by A1. And I don't think we were looking to reach out and decide a lot of questions that weren't before us. I think, and this was 8 justices joined this opinion, it just seemed the sort of obvious understanding of the statutory scheme. So, even if it's dicta, it reflected what 8 people thought was pretty obvious when you looked at the statute.
So, Justice Kagan, if I can take that in 2 pieces. So there are 2 sentences there. The first one you referred to talks about a presumption in the statute that the notice of hearing will follow the notice to appear. And I agree. I don't think that there is any dispute that there is such a presumption in the statute. But identifying that presumption does not answer the question in this case, which is what happens when the presumption is not met and the notice to appear did not contain the time and place information. Then the second statement, which I acknowledge is a difficult statement for me, is the statement about the meaning of change. And I do think that's dicta. I also think it's incorrect dicta. And it's not surprising the court got that incorrect because it just did not have the evidence, like the dictionary definitions, like the contextual evidence about the meaning of change that we have brought to the court's attention in our briefing in this
case. Mr. McLeod, that seems to beg the question. The finding in that case, and since I wrote it, was that the statutory presumption commanded by Congress, who knew full well that the government was giving notices with TBAs, time and place to be announced regularly, was contrary to that history. They wanted these notices to be full and complete. That's what we held. And having held that, I think there's a presumption that you have to look at the statute in that context, that there will always start with a proper notice to appear, and if you're going to change the time and place, you're going to give a new time and place. I don't understand that a new time and place is something different than what you've already specified.
And Justice Sotomayor, in this case, we think that we did satisfy that burden because we did provide a new time and place. We told the non-citizens where their removal hearings would be held, and so they had the information they needed to attend. And so I don't think that change is actually the operative word in the statutory scheme, but I don't want to fight you too hard on that because I do think that even if you think that notice of hearing must change a previously set time or place for the hearing, that requirement is satisfied here because the ordinary meaning of the word change is very broad, and it encompasses the process of going from—
So change is no change, meaning you haven't set a time and place, and we're going to change that and set what? Another no time and place?
Your Honor, what we have done—
No, it's going to be a time and place now.
Your Honor, what we have done in the TB and TAs is to tell the non-citizen you are going to have a hearing. We don't know when that hearing will be, but we have changed from that placeholder time to a specific time. And we think that under the ordinary meaning of change, particularly as it's used in this statutory scheme, going from an indeterminate time and place to a determined one is a kind of change.
Mr.
Mr.
McLeod,
Didn't you lose that argument in Chavez? I mean, I understand and take your point, but I thought the court said you really couldn't interpret the statute in that way or the word change in that way.
Respectfully, Justice Jackson, I don't agree. I think the only issue that the court decided in Chavez was whether we could compile two documents together to create a notice to appear, and the court said that that definite Article A indicated that the notice to appear needed to be a single document. And so we are not disputing for purposes of these cases that the notices to appear alone could not be the basis for in absentia removal. But what's critical about this case and what distinguishes this case from Pereira and Chavez is that Congress here created two forms of notice, and it made both of them relevant for purpose of in absentia removal in a way that they are not relevant for purposes of
Can you say more about that, two forms of notice? What do you mean?
I mean that they created both the paragraph 1 notice, the notice to appear, and the paragraph 2 notice, the notice of hearing, or as the other side refers to it, the notice of change.
So you think those operate completely independently of one another?
They're independent in the sense that they can both be independent, valid bases for in absentia removal. I take the point that the notice to appear is what initiates the proceeding, and so some sense you need to have a proceeding in order for there to be a notice of hearing to alter that proceeding. But I don't think it is the case that the TBD status of the notice to appear in any way invalidates the later notice of hearing. And that's because the statute is very clear about the requirements for a valid notice of hearing. It needs to set the new time and place, and we did that in this case.
Mr. McLeod,
After failing to appear, and we don't have any way to remedy that going forward. And if the Ninth Circuit's rule stands.
I appreciate the force of the point, Mr. McLeod, but there are so many people because the government was out of compliance with the statute for so long. And so at a certain point, it's just you can't sort of ask us to read the statute against what the statute says, because we've created a world in which kind of we've long since forgotten what the statute says.
So respectfully, Justice Kagan, that's not what we're asking you. We're asking you to apply the statute as it's written, and that is a statute that permits in absentia removal when a non-citizen received notice under either paragraph 1 or paragraph 2. And all the non-citizens here got the paragraph 2 notice. They haven't contested that they received notice of when and where to show up.
That's what most fundamentally I find a little bit discomforting about your argument, this idea that there are two forms of notice. Take your pick. If one is good, who cares about the other? I mean, it seems to me that if you read this statute fairly, it's quite clearly, and this is what we said in our two prior cases, you know, A1 is the notice. That's the notice. And what A2, it tells you what you have to put in it, all the things that you have to do. Here are the charges. Here's your right to counsel, and here's when you're supposed to show up. And what A2 was about is Congress understood that there were going to be times when you were told to show up on March 15th, and then it turned out that March 15th was impracticable or impossible for any of a number of reasons. And it was a mechanism to say, okay, we don't mean March 15th, instead show up on August 15th. But that's what the function of A2 is. It's not some completely distinct form of notice that you can say, hey, look, we did that one.
I just disagree, Your Honor. I think that the A2 notice serves a distinct purpose, and that purpose is to provide the non-citizen with the information they need to know in order to decide whether they want to attend the removal hearing or not. And all of the non-citizens.
Doesn't it also serve the purpose of giving the government the right to remove them in absentia? I mean, the thing that's a little concerning to me about the way the government has constructed its argument here is the suggestion that we ignore 1229A5A, which requires the government to give the person notice as a prerequisite for the government's ability to take advantage of the procedure of removing them without a hearing. So I guess I'm a little concerned that what you're suggesting is that we should presume that the removal is proper, the removal order is proper, even if the notice was defective. And now it's on the non-citizen to say something, or it shifts to his burden to prove, that he should not be removed under those circumstances.
A couple of responses, Your Honor. First, we are not asking you to read out of the statute the paragraph 2 notice or to ignore the paragraph 1 notice. We're saying both of those notices are relevant for purposes of in absentia removal, and we bear the burden as the government of proving that the non-citizen got notice. But that notice can be in the form of the paragraph 1 notice or the paragraph 2.
But how do you square that with the prior cases? I don't understand your distinction. Maybe I would understand it if we hadn't already looked at this same circumstance to determine whether a notice is defective and what is the consequence of that. So in Pereira, we said if it doesn't have the time or place, the notice to appear, then it's defective. And as I read Nies-Chavez, we say the government can't cure that deficiency for the purpose of the stop time rule by providing a paragraph 2 notice. So the government, I think, has to say there's something different about this scenario, the removal scenario in absentia, than the stop time rule scenario.
And there are two significant differences.
Okay.
Right? One is textual and one is based on legislative history and drafting. So the textual difference is that for purposes of the stop time rule, the only notice that is relevant is the notice to appear. That is the only notice that is referred to in that provision.
Why do you say that? I'm sorry.
Because when you look at the text of the stop time rule, it says it is triggered based on the service of a notice to appear. There is no reference to the notice of hearing.
But it says...
Justice Kagan?
And if I could just understand, I mean, given that you say you don't have a lot of evidence that the founding or the generation that we're looking at is really thinking about office versus officer of the United States, I mean, it would suggest that we should ask, is that a rule a sensible one? You know, if they had thought about it, what reason would they have given for that rule? And it does seem as though there's no particular reason, and you can think of lots of reasons for the contrary, to say that the only people who have engaged in insurrection who are not disqualified from office are presidents who have not held high office before. Why would that rule exist?
I don't think there is a good rationale given that this was compromised legislation. And sometimes this happens with statutory compromises and even constitutional compromises. There's an agreed upon set of words that can pass both houses of Congress. But different legislators may have had goals and motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And it does seem odd that President Trump would fall for motivations. They didn't all get their way. In a compromise, everyone goes away miserable. But this was the text that was settled upon. And it does seem odd that President Trump would fall through the cracks in a sense. But if officer of the United States means appointed officials, there's just no way he can be covered under Section 3. The court would have to reject our officer argument to get to that point.
And is there any better reason if you go to the office argument that Justice Jackson was suggesting, is there any better reason for saying that an insurrectionist cannot hold the whole panoply of offices in the United States, but we're perfectly fine with that insurrectionist being president?
I think that's an even tougher argument for us to make as a policy matter, because one would think of all offices, the presidency would be the one you'd want to keep out the Confederate insurrectionists. That's the commander-in-chief of the Army. So, again, that's why we're leaning more on the officer of argument than the office under. We're not conceding office under, but we definitely have the stronger textual case and structural case on officer of the United States.
Thank you.
Thanks.
I just want to sort of understand your position, and I want to narrow this to the paradigmatic social media companies, sort of news feed postings, Facebook, YouTube, Twitter/X. So suppose that that I say, just take this as a given. All right, you can argue with the facts, but don't. Suppose that I say, for the most part, all these places say we're open for business. Post whatever you like and we'll host it. But there are exceptions to that, and clearly content-based exceptions, which the companies take seriously. So let's say they say we think that misinformation of particular kinds is extremely damaging to society. Misinformation about voting, misinformation about certain public health issues. And so, too, we think that hate speech or bullying is extremely problematic. And so we are going to enforce rules against this. If they're only going to apply to a small percentage of the things that people want to post, for the most part, they're open for business. But we are serious about those content-based restrictions, all right? So in that world, why isn't that a classic First Amendment violation for the state to come in and say we're not going to allow you to enforce those sorts of restrictions, even though, you're basically, it's like an editorial judgment. You're excluding particular kinds of speech.
Well, Your Honor, I think I take your hypo to be assuming that it's First Amendment protected activity, and I think that what you would do in that instance, you would have to run intermediate scrutiny under Turner, and the analysis regrettably.
So don't say what I take it to be First Amendment activity. I mean, do you take it to be First Amendment activity?
No, that's our whole point. I mean, again,
even though they're saying, yeah, we are a big forum for lots of messages, but not for those kinds of messages. We want to exclude those kinds of messages. Why isn't that First Amendment a First Amendment judgment?
I mean, I think the court held otherwise, I think, in Pruneyard, because there was an editorial policy against leafleting, too. And again, I don't...
No, that was just about leafleting, and the mall owner didn't have any expressive views. I'm taking as a given that these, the YouTube or Facebook or whatever, has expressive views. There are particular kinds of expression defined by content that they don't want anywhere near their site.
But I think, Your Honor, you still would have to look at the objective activity being regulated, namely censoring and deplatforming, and ask whether that expresses a message. And because they host so much content, an objective observer is not going to readily attribute any particular piece of content that appears on their site to some decision to either refrain from or to censor or deplatform.
Do you think so as to this? This is a real-world example. Twitter users one day woke up and found themselves to be ex-users, and the content rules had changed, and their feeds changed, and all of a sudden they were getting a different online newspaper, so to speak, in a metaphorical sense, every morning. And a lot of Twitter users thought that was great, and a lot of Twitter users thought that was horrible, because, in fact, there were different content judgments being made that was very much affecting the speech environment that they entered every time they opened their app.
Your Honor, respectfully, that does not answer whether they have a message in their censorship, any more than, I'm sure people objected, again, quite strenuously to the fact that the law schools were permitted to interview on campus. I'm sure people wanted to ban leafleting at the mall in Pruneyard, and that does not give them a message in that. And I think the reason for that is if they are not carefully selecting the content in the newspaper, they don't have a message in the mere existence of the content on the
Thank you, General.
Justice Kagan?
I mean, let me ask the same kind of question in a different way. Suppose that instead of this law, you had a law that was focused, it excluded the kind of curated news feeds where your argument about editorial discretion sort of leaps out. So this law didn't touch those. But it said, with respect to Gmail and direct messaging and Venmo and Dropbox and Uber, with respect to all of those things, a site could not discriminate on the basis of viewpoint, just as maybe a site couldn't discriminate on the basis of race or sex or sexual orientation or what have you. So it just added viewpoint to the list. Wouldn't that be all right?
I actually don't think it would be all right, because all of those things are still in the expressive business. And I also think...
Well, do you think that, suppose it didn't say viewpoint, it just said you can't discriminate on the basis of, all the usual protected characteristics? Is that all right?
That would probably be all right, but it wouldn't save the whole statute from being...
Well, so this is just on this statute. It's a statute about... it excludes YouTube and Facebook and the Facebook news feed.
Right.
But it's just direct messaging, Venmo, all of those kinds of things. And it just said, we're not going to let you exclude on the basis of race and sex, and we're also not going to let you exclude people on the basis of viewpoint.
So, I mean, the first part of that statute, I don't think my clients would even challenge. I mean, whether there's an abstract First Amendment right to have the Black Authors Table for Black History Month.
And also on the basis of viewpoint.
When you throw viewpoint into there, then I think, I'd have to ask my clients whether they challenge that statute. But obviously, that's not the statute we have here. And if you think about,
I guess what I'm saying is in part, it is the statute you have here, and that gives you your plainly legitimate sweep, because all it's saying is that when you run a service where you're not speaking, unlike in Facebook feed, where your editorial discretion argument is good because the platform is engaged in speech activities. Well, when you're running Venmo, you're not engaged in speech activities. And so when a state says to you, you know what, you have to serve everybody, irrespective of whether you like their political opinions or not, then it seems you have a much less good argument. But this statute also says that, doesn't it?
Not really, Justice Kagan, and I think we're in danger of losing sight of the actual statute. So let me take you to Petition Appendix 97A and the definition of censor used in the statute. It says censor includes any action taken by a social media platform to delete, regulate, restrict, edit, alter, inhibit the publication or republication of, suspend a right to post, remove or post an ad addendum to any content or material posted by a user. The term also includes actions to inhibit the ability of the user to be viewable or to interact with another user of the social media platform. Censor is all about the expressive activity. Post prioritization is all about, it specifically talks about a news feed, a view, search results, and they give essentially political candidates in journalistic enterprises a right to sort of non-discrimination. So they're going to pop up there, even though, like, I have no interest in politics. I just want to look at, feeds about Italian bicycles. And I'm still going to get these Florida politicians popping in there. That's what this statute does. And then you go through shadow ban. Shadow ban's not about any of the things you're talking about. Shadow ban is all about content. And then we go to journalistic enterprises. They get pride of place. Then we talk about post-prioritization. That's all about how you display the content. So, like, maybe the 30-day provision, you could sort of say that, well, that applies to, like, Uber. But even then, if Uber wants to change its comment policies because all of a sudden, they did one thing to try to, deal with one set of issues, and then a problem comes up and there's a whole bunch of, like, people using the comments in a really rude way, like, why couldn't they change their editorial policy on the comments? I just don't understand it. And then all of the duty to explain provisions, the duty to explain provisions are all driven by decisions to exclude content. And that happens 1 billion times a quarter at YouTube. So that's a crushing blow. It has nothing to do with some of the other things you're talking about.
Thank you. And could I just understand, because it seems like an extremely expansive argument, I must say, encouraging people basically to suppress their own speech. So, like Justice Kavanaugh, I've had some experience encouraging press to suppress their own speech. You just wrote a bad editorial. Here are the 5 reasons you shouldn't write another one. You just wrote a story that's filled with factual errors. Here are the 10 reasons why you shouldn't do that again. This happens literally thousands of times a day in the federal government.
Yeah, and I would say in the Meinrad case that you're describing to me, it's the government going after the speaker itself and trying to get them to change their speech. What's so pernicious here is that you don't see any of these facts in this record unless we get discovery, which is when Rob Flaherty, who's Deputy Assistant to the President, sends an email to Facebook or to Twitter and complains that they're not doing enough to censor what they view as vaccine hesitancy speech. America never sees that, and the third party, people like Jill Hines and Jim Hoft, whose speech wishes to express the kinds of viewpoints that the White House is targeting, they never know that that's happening behind the scenes. And I think it makes a difference, Justice Kagan, that you have an intermediary here who really has no incentive to itself defend Jim Hoft's speech or to defend Jill Hines' speech. In the New York Times hypothetical, you have a storied publication that itself is familiar with those kinds of
op-eds? What about op-eds?
Your Honor, and with op-eds, if it's a third-party speech that
that happens too, right?
And I guess there are a number of ways I would think about that, Your Honor. One is if the newspaper declines to run an op-ed because the government asked, that op-ed author can go to any number of other publications and it has an outlet. It's not the same here, because if I'm on Twitter and I wish to express a viewpoint that the government wishes to censor and Twitter bows to that pressure, then I lose my account.
I was just going to say, first, I have no experience coercing anybody. But second, I mean, the government is not monolithic either. I suspect when there's pressure put on one of the platforms or certainly one of the other media outlets, they have people they go to, probably in the government, to say, hey, they're trying to get me to do this, and that person may disagree with what the government's trying to do this. It's not monolithic, and that has to dilute the concept of coercion significantly, doesn't it?
Your Honor, I'm not sure I agree with that, and I guess I'd get back to one of the earlier points I made, which is, whether you call this coercion, if that's the label you attach, you call it encouragement, you call it promotion, you call it inducement. Whatever it is, if the government is attempting to abridge the speech rights of a third party, that has to be unconstitutional because that falls within the plain text of the First Amendment. And so, this is Bantam Books of the 21st century. You haven't had a case with social media platforms like this where third-party speech is so at risk of being censored.
Well, but how do you analyze a situation where, maybe EPA is trying to coerce the platform about something and the Army Corps of Engineers is trying to coerce them the other way? I mean, you can't just sort of pick and choose which part of the government you're concerned about.
Your Honor,
and obviously it's a different when you're talking about what the president is saying in particular, but other than that, I think it's a very more fluid situation than anything else.
It is fluid, Your Honor, but I would say that when you have, as we have plaintiffs in this case who wish to express certain viewpoints that have been specifically targeted by the government, it's not at least fluid in these facts. And this is not a case just about COVID. It's a case about election integrity. It's a case the district court has a finding about how the government.
So, I mean, what
wishes
about
to.
that? I mean, take an example where, I mean, these platforms, they're compilers of speech, and some part of the government, let's call it part of the law enforcement arm of the government, says you might not realize it, but you are hosting a lot of terrorist speech, which is going to increase the chances that there's going to be some terrible harm that's going to take place. And we want to give you this information. We want to try to persuade you to take it down. The government can't do that?
The government can absolutely do that, Justice Kagan.
They're asking them to take down the speech.
Terrorist activity, criminal activity that is not protected speech, absolutely, the government can inform
Well, that might be protected speech. I mean, terrorists engage in, things that come under the First Amendment. I mean, let's say they're just recruiting people for their organizations.
Your Honor, if it's First Amendment speech, protected speech, then I think we're in an entirely different world. I mean, that's a case where, and this comes up in the FBI findings that the district court made, because what was happening is the FBI was sending teleporter encrypted messages to the platforms identifying what the government represents was foreign actors. The district court found the government was not distinguishing between whether it was domestic or foreign conduct. And the way this issue arises is when maybe you have a foreign actor who tweets, I love Biden, and there are 20 million people who wish to retweet that, repost that with their own comments saying, heck yeah, I love Biden too. When an American does that, that's First Amendment protected speech, Your Honor. And so when the government comes in and tries to take down every single post that contains the core that they say was foreign speech, but they're also taking down the added speech by Americans, that's a square First Amendment issue, Your Honor.
So back in this still happens now. Decades ago, it happened all the time, which is somebody from the White House got in touch with somebody from the Washington Post and said this will just harm national security, and the Washington Post said, okay, whatever you say. I mean, that was all. That we didn't know enough, but that was coercion.
Your Honor, I thought I understood the government this morning to say that might be a First Amendment issue. And I think what I would say is if there's a national security interest, maybe the government can satisfy strict scrutiny in that circumstance. What I would also say is we probably wouldn't have a lawsuit based on that, because I don't know how that we would get prospective injunctive relief based on a fleeting, offhand, reach out from the White House.
I guess what I'm just trying to suggest is that there's all kinds of things that can appear on these platforms that do all kinds of different harms, and the inability of government that you're suggesting to reach out to these platforms and say, we want to give you information that you might not know about on this, and we want to give you our perspective on what harms that this is doing. And we want to be able to answer questions that you have because we really do think that it would be a good thing if you, on your own, chose to take this speech down.
So can I talk about that, Ms. Kapoor? So taking Robinson as a given, could you criminalize the status of homelessness?
Well, I have a couple points to that.
It's just a simple question.
So Robinson doesn't address that, and I think it's completely distinguishable. So Robinson was...
Could you criminalize the status of homelessness?
Well, I don't think that homelessness is a status like drug addiction, and Robinson only stands for that.
Well, homelessness is a status. It's the status of not having a home.
I disagree with that, Justice Kagan, because it is so fluid, it's so different. People experiencing homelessness might be one day without shelter, the next day with. The federal definition contemplates various
At the
forms.
period with which, in the period where you don't have a home and you are homeless, is that a status? Could
No.
you criminalize that?
No, it's not. So Robinson talked about addiction like a disease.
You could criminalize just homelessness.
So I want to say first a couple of things. So I think that for the...
I mean, that's quite striking.
No, I don't.
That you think that you can criminalize just homelessness.
No, we're not saying that homelessness is a status, but most importantly, I think the Eighth Amendment is the wrong way to focus on this question.
It's really a simple question. Can you criminalize homelessness? And you're suggesting, yes, you could.
No, we do not criminalize homelessness. I'm not saying...
Could you criminalize homelessness? Not tell me what you do, what you don't do. Could you?
So I think there would be due process problems and vagueness problems. I don't think there's an Eighth Amendment problem in the sense of Robinson, because that was a limited decision where the holding was solely about a disease of addiction. The court was very clear about distinguishing between addiction and possession or use. And so...
You're right that it's a different status that was involved in Robinson. But Robinson made clear that there was a category of cases which were status offenses, which were different from conduct offenses. And when you started off here today, you said we're just criminalizing conduct. So to tell you the truth, I thought that this was going to be a question where you would say, no, of course we can't criminalize a status, but there's conduct here. And then I was going to say, what is the conduct here? But you didn't say that. You said you could criminalize even the status of homelessness. And that suggests to me that you're off on the wrong track in thinking about this issue.
So, Justice Kagan, I think the point where we are disagreeing here is really about whether the Eighth Amendment is the right framework for this discussion.
Well, the Eighth Amendment was the framework in Robinson. And so taking Robinson as a given, where Robinson said the Eighth Amendment protects you against status-based crimes, that's what the question is.
I don't think Robinson extends that far. I think Robinson itself was cabin, and I think the Justice Marshall's plurality in Powell goes into a discussion about this and how that was the right line.
What is the conduct here?
The conduct is camping, establishing a campsite, and it's the same as in the federal regulations that the National Park Service
So I didn't
relies
think
on.
that was the conduct. I thought that the only conduct here was sleeping outside with a blanket.
No, it is the conduct of establishing a campsite, which includes making a bed with bedding or other materials, and the federal law...
A campsite suggests something different to people. It suggests a tent. It suggests a conglomeration of people, tent camps, if you will. But your ordinance does not just prohibit that. Your ordinance prohibits a single person who is homeless, so does not have another place to sleep. That's a status. I don't have another place to sleep. A single person sleeping instead in public with a blanket. That's what I understand your statute to do. Is that not what your statute does?
The statute does not say anything about homelessness. It's a generally applicable law. It's very important that it applies to everyone.
Yeah, I got that, but it's a single person with a blanket. And you don't have to have a tent. You don't have to have a camp. It's a single person with a blanket.
And sleeping in conduct is considered, sleeping in public is considered conduct. And this court in Clark discussed that is conduct. Also, the federal regulations
sleeping is a biological necessity. It's sort of like breathing. I mean, you could say breathing is conduct too. But presumably, you would not think that it's okay to criminalize breathing in public.
I would like to point to the federal
And
regulations.
for a homeless
which I brought
person
up.
who has no place to go, sleeping in public is kind of like breathing in public.
Well, 2 points. So first, even the federal regulations prohibit even sleeping. They don't even require any materials, including but not necessary under the federal regulations. So this is conduct that is understood by jurisdictions nationwide and even the federal government to be conduct that is prohibited. And so I want to make that point. The
I'll
second
tell you
point,
the truth, Ms. Kapoor. I think this is a super hard policy problem for all municipalities. And if you were to come in here and you were to say, you know, we need certain protections to keep our streets safe, and we can't have, you know, people sleeping in any place that they want, and we can't have, you know, tent cities cropping up. I mean, that would create one set of issues. But your ordinance goes way beyond that. Your ordinance says, as to a person, and I understand that you think it's generally applicable, but we only come up with this problem for a person who is homeless, who has the status of homelessness, who has no other place to sleep. And your statute says that person cannot take himself and himself only and, you know, can't take a blanket and sleep someplace without it being a crime. And that's, you know, well, it just seems like Robinson. It seems like you're criminalizing a status.
well, it is not, and we agree with you that this is a very difficult policy question, and that's exactly why the Eighth Amendment.
Justice Kagan?
You've referred a couple of times to the necessity defense, so could you tell me how that would work?
Yes. So there, under Oregon law, if a person says that it's effectively the lesser of two evils, if they say I had no alternative to no legal alternative other than what I did here that broke the law, then I had no choice, and I therefore had to break the law, and it was in some sense involuntary, to use a term that many have been discussing. So there, it would be very narrow. It is a very narrow defense, so it would be in that moment.
So suppose that there is a person who is homeless, and there are no shelter beds available, and the person has no place to go, and the person, of course, has to sleep. And the person, it's cold outside, the person has a blanket. So that's the minimum conduct that the law prohibits. So the person sleeps outside with a blanket, and the police officer comes, but the person says, well, I had no place else to go. Would the city continue to push for some kind of penalty?
Well, there, if a person received a citation, so if they did, then they would have a defense of necessity. It's asserted as a defense. So what the other side is
Well, it's asserted as a defense.
Yes.
I mean, so you're not willing to say, no, we're going to tell all our police officers that they shouldn't give a citation in that circumstance. You know, we're going to give a citation, and then we'll see how the courts deal with it, is all you're going to tell me.
Officers always have discretion, and we know that they exercise it, and it's hard to know.
The question is not an individual officer's discretion. Individual officers are in a tough situation here.
They are.
The question is, what is the city going to tell individual officers? So what is the city going to tell individual officers about a case of the kind that I said? Are you going to tell individual officers, issue the citation, and we'll see if the person knows enough to make a necessity defense, and we'll see what the court does about that? Or are you going to say, you know, there are some things that just ought not to be the subject of civil or criminal infractions?
So the city, in its policy, at a joint appendix, page 158, for example, talks about what officers are supposed to do. They're supposed to put people in touch with services first, to contact if there is available help for them. These laws are absolutely a tool for getting people the services that they need. Many people need that intervention.
Well, you're not giving me a real answer to the question of, is the city telling officers that they should give citations in that circumstance?
No, it is if somebody, again, it is a matter of discretion.
Is there anything you can point? It's a matter of discretion.
Yes.
There's nothing you can point to that the city says, we have a necessity defense. What we're telling officers to do is to, you know, act consistently with that defense so that if it is truly a matter of need that you are sleeping on the street alone with a blanket, no, the officer should not cite the person?
There's nothing in the record here that shows officers were told about a necessity defense and that what it would or would not preclude. That would be an individualized question after the fact if someone received a citation. And if they thought that that wasn't enough, the proper framework would be this court's framework in Kaler, where we would look at the asserted defense, their insanity of some form, and here it would be necessity, and we would ask whether it is so deeply rooted in our history and something that has to be imposed in this way on the states.
Thank you.
Justice Kagan?
Can continue on in Justice Barrett's vein a little bit and ask you about some of the allegations of the indictment and whether they're official acts or not in your view. So the defendant signed a verification affirming false election fraud allegations made on his behalf in a lawsuit filed in his name against the Georgia governor.
I don't think we've disputed that that's official. I'm sorry, that is unofficial.
That's unofficial. Same for the defendant called the chairwoman of the Republican National Committee, asked her to gather electors in targeted states, falsely represented to her that such electors' votes would be used only if ongoing litigation in one of the states changed the results in the defendant's favor.
We have taken the position that that is official.
That's official?
Yes.
Why would that be official?
Because the organization of alternate slates of electors is based on, for example, the historical example of President Grant is something that was done pursuant to and ancillary and preparatory to the exercise of the core recommendation clause power. So when President Trump
couldn't he have taken this action just in the status of a candidate?
The fact that he could have done so doesn't demonstrate that he did do so in this case, and based on the allegations, we think it's clear he did not, that this was done in an official capacity.
The defendant asked the Arizona House Speaker to call the legislature into session to hold a hearing based on their claims of election fraud.
Absolutely an official act for the president to communicate with state officials on a matter of enormous federal interest and concern, attempting to defend the integrity of a federal election, to communicate with state officials and urge them to view what he views as their job under state law and federal law. That's an official act.
Well, attempting to defend the integrity of the election, I mean, that's the defense. The allegation is that he was attempting to overthrow an election.
Essentially, exactly right. And neither allegation of what the purpose is should make a difference as to whether it's immune. That is extremely strong precedent from this court.
Does it strike you as odd that your understanding of immunity goes way beyond what OLC has ever claimed for a former president?
I view the OLC opinions here as strongly supporting us, because any time a congressional statute basically got anywhere near touching the president's prerogatives, they've said, oh, we're going to interpret the statute narrowly to avoid that. So
well, that's a different question. I mean, what OLC has always said is that sitting presidents get immunity, but former presidents, no. Now, there might be a different argument made about whether a statute or whether a statute as applied to particular conduct is properly available against the president. But that's a very different argument than the immunity claim that you're making here, which OLC has definitively not supported.
I don't know if I put it that way. I don't recall an opinion directly addressing it, but more fundamental to us, Your Honor, is in fact the language of cases like Marbury and statements like made by Benjamin Franklin at the Constitutional Convention, statements of George Washington talking about the massive risk of factional strife and how that could destroy the republic and erect a new government on the ruins of public liberty. That's what we rely on principally here. I cite the OLC opinions because, of course, what you see there is a very strong trend that if there's any statute that might trench in any way on the president's prerogatives, which they interpret it to avoid that.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the Blazing Game analysis or even the Fitzgerald analysis that we've been talking about.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that might well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that—
Well, he's gone. Let's say this president who ordered the military to stage a coup. He's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time. And he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand, because the framers viewed that kind of
If it's an official act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific, context-specific determination.
That answer sounds to me as though it's like, yeah, under my test, it's an official act, but that sure sounds bad, doesn't it?
Well, it certainly sounds very bad, and that's why the framers have a whole series of structural checks that have successfully, for the last 234 years, prevented that very kind of extreme hypothetical. And that is the wisdom of the framers. What they viewed as the risk that needed to be guarded against was not the notion that the president might escape, a criminal prosecution for something, sort of very, very unlikely in these unlikely scenarios. They viewed much more likely and much more destructive to the republic the risk of factional strife discussed by George Washington.
The framers did not put an immunity clause into the Constitution. They knew how to. There were immunity clauses in some state constitutions. They knew how to give legislative immunity. They didn't provide immunity to the president. And, not so surprising, they were reacting against a monarch who claimed to be above the law. Wasn't the whole point that the president was not a monarch and the president was not supposed to be above the law?
I would say two things in response to that. Immunity, they did put an immunity clause in a sense. They put in the executive vesting clause, which was originally understood to adopt a broad immunity principle that's set forth in the very broad language of Marbury against Madison. And also, they did discuss and consider what would be the checks on the presidency. And they did not say, oh, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says we don't have that. That's not an option. Everybody cried out against that as unconstitutional. The structural check we're adopting is impeachment. And they're very clear on that in pages 64 to 69 of the second volume of Farrand.
Thank you.
Justice Kagan?
Mr. Dreeben, I want to go through your framework and make sure I understand it. So first, on the small category of things that you say have absolute protection,
yes,
that they are core executive functions.
Yes.
What are those small categories?
Pardon power.
Pardon, veto.
Veto, foreign recognition, appointments. Congress cannot say you can't appoint a federal judge who hasn't received, a certain diploma, hasn't achieved a certain age. There are a few other powers.
Is Commander-in-Chief?
Commander-in-Chief is on the list, but I want to add to my answer on that Congress has substantial authority in the national security realm. Congress declares war, it raises armies, it has power over the purse. That's more
so
of
that may be viewed as not really in that core set of functions which nobody has any power but the president over.
Yes, I think that there may be some aspects like directing troops on the field in which the president's power is completely unreviewable.
Okay. Now, in the next category, where we've left the core set behind,
yes,
but we're still in the world of official actions, and that's where you say there are various statutory construction rules that might come into play.
Correct.
But you have characterized those as something different from just saying, oh, look, the statute doesn't say the president, therefore it doesn't apply to the president.
That's right.
So I wanted to give you an opportunity to say, how that would look, how that analysis would look in a given case. And in the course of responding to that, I'm sort of thinking of something like the OLC opinion, which says bribery. The president can be tried and convicted of bribery, even in the part of the bribery statutes that do not say the president. Why is that true?
That is true because there is no serious constitutional question that the president needs to engage in bribery in order to carry out his constitutional functions. And the Office of Legal Counsel pointed out that bribery is enumerated in the impeachment clause. So it falls outside of anything that could be viewed as inherent in the need of Article 2 to function.
Do you think the premise of that OLC opinion was that the bribery was simply not official?
No.
Or is the premise that the bribery was official and still the president could be prosecuted for it?
I think that the bribery is the kind of hybrid that illustrates the abuse of public office for private gain that we think is paradigmatic of the kinds of things that should be not held to be immune. In a bribery case, the public official cannot extract the bribe without the official power to offer as the quid or the pro. I guess the quo, actually. So it really is a crime that can only be committed by public officials who misuse their power. And it was one of the things that was most mistrusted. Many of the acts that are charged in this indictment or that would violate federal criminal law similarly involve the misuse of official power for private gain.
So if you were to say like what the line is in this category, like when it is that the statute should be understood as precluding presidential prosecution, and when it is that the statute should be understood as allowing it, what general principles should guide?
So the general principles, I think, kind of emerge from looking at what the Office of Legal Counsel has done. So, for example, with respect to a federal statute that prohibited appointments to courts of people within certain degrees of consanguinity, the Office of Legal Counsel said this infringes on a very important appointment power of the president, the power to appoint federal judges. It cannot be presumed that Congress intended to do that because it would raise a very serious constitutional question. The president is out. Then there are categories of statutes where the president is in, like, for example, the grassroots lobbying statute. The Office of Legal Counsel wrote an opinion about that, and it said, for the president or other public officials to go out into the world and to promote their programs, that can't be what Congress intended to prohibit. What it did intend to prohibit is using federal funds to gin up an artificial grassroots campaign that gave the appearance of emerging from the people, but it was really top down. And the Office of Legal Counsel said the president and officials who carry out the president's mandates are subject to that statute. So that's a more nuanced one. And the third example that I will give you is the statute that would permit prosecution for contempt of Congress. The Office of Legal Counsel concluded that a good faith assertion of executive privilege as a reason for not providing information to Congress would preclude prosecution because Congress cannot be deemed to have altered the separation of powers in such a manner. I think OLC probably would have gone on to say if Congress tried to do it, it would be deemed unconstitutional. But again, this was a statute that did not specifically name the president. There are only two that do that. So the entire corpus of federal criminal law, including bribery offenses, sedition, murder, would all be off limits if it were taken to the extent that some of the questions have suggested. And for the general principle, does it raise a serious constitutional question? And if so, to what extent? Can it be carved out individually? And there may be some instances where the statutes here could be carved out and a particular act could be found to be protected. Or does the statute across the board in such a wide range of applications, somewhat analogous to overbreadth analysis, infringe on the president's power so that we're going to say that the president is just out?
Now, that set of issues, they seem important and may occasionally be difficult. They also seem not really before us in the way Justice Jackson suggested earlier. What do you do you think they are before us? We should just clear it up. Here it is. We have a case. What else could we do? How should we deal with this? That there are these lingering issues that go beyond the question of whether there's the kind of absolute immunity that the former president is invoking.
So I think the court has discretion to reach that issue, even though Justice Jackson is totally right. It was not raised in the district court, and it was not raised in the Court of Appeals. And the analysis that I would use to get there is a fusion of a couple of principles. One is the court has often resolved threshold questions that are a prerequisite to an intelligent resolution of the question presented. So in a case like United States versus Grubbs, for example, the court reached out to decide whether anticipatory warrants are valid under the Fourth Amendment before turning to the question whether the triggering condition for an anticipatory warrant had to be in the warrant. So that's one principle. And then a precedent that bears some analogy to this is Vermont Natural Resources Agency versus United States ex rel Stevens. It was a qui tam case, and the first question was whether a state agency was a person within the meaning of the False Claims Act, and the second question was whether if the state agency was 11th Amendment immunity kicked in, and the court wrote an analysis of why it could reach both questions. The reaching the person question didn't expand the court's jurisdiction, and it made sense as a matter of constitutional avoidance to do that. There are some considerations that cut against this, and I want to be clear that for overall government equities, we are not wild about parties who raise an immunity case that can be presented to a court on an interlocutory appeal and then smuggling in other issues. So we would want to guide the court not to have an expansive approach to that issue. But the final thing that I would say about this is part of our submission to this court is that the Article 1 branch and the Article 2 branches are aligned in believing that this prosecution is an appropriate way to enforce the law. Congress, by making the law, the current executive by deciding to bring it. And since a building block of that submission is that Congress actually did apply these criminal laws to official conduct, the court may wish to exercise its discretion to resolve that issue.
Okay, I have one last set of questions, which has to do with the official unofficial line.
Yes.
And you heard Mr. Sauer's responses to both Justice Barrett's questions and my questions about what he thinks counts as official here and what he thinks counts as unofficial here. And I'm just wondering what you took from his responses and also how you would characterize what is official and what is not official in this indictment.
So I think petitioner conceded that there are acts that are not official that are alleged in the indictment, and we agree with him on all of that. I think I disagree with him on everything else that he said about what is official and what is not. Organizing fraudulent slates of electors, creating false documentation that says, I'm an elector, I was appointed properly, I'm going to send a vote off to Congress that reflects that petitioner won rather than the candidate that actually got the most votes and who was ascertained by the governor and whose electors were appointed to cast votes. That is not official conduct. That is campaign conduct, and I think that the D.C. Circuit in the Blassingame case did draw an appropriate distinction. A first-term president who's running for re-election can act in the capacity as office seeker or office holder. And when working with private lawyers and a private public relations advisor to gin up fraudulent slates of electors, that is not any part of a president's job. So
there's an allegation in the indictment that has to do with the removal of a Justice Department official. Is that core protected conduct?
We don't think that that's core protected conduct. I don't think that I would characterize that episode quite that way. We do agree that the Department of Justice allegations were a use of the president's official power. In many ways, we think that aggravates the nature of this offense. Seeking as a candidate to oust the lawful winner of the election and have oneself certified with private actors is a private scheme to achieve a private end, and many of the co-conspirators alleged in the indictment are private. But for an incumbent president to then use his presidential powers to try to enhance the likelihood that it succeeds makes the crime, in our view, worse. And so in the Department of Justice episode, it occurs very late in the election cycle after many other schemes had failed. And at that point, the petitioner is alleged to have tried to pressure the Department of Justice to send false letters to the states claiming that there were serious election irregularities and that they should investigate who they certified as the president. None of this was true. The Department of Justice officials all said, this is not true. We are not going to do that. And at that point, petitioner is alleged to have threatened to remove the Department of Justice officials who were standing by their oath and replace them with another person who would carry it out. We're not seeking to impose criminal liability on the president for exercising or talking about exercising the appointment and removal power. No, what we're seeking to impose criminal liability for is a conspiracy to use fraud to subvert the election, one means of which was to try to get the Justice Department to be complicit in this. The case would have been no different if petitioner were successful and he had actually exercised the appointment and removal power and it had gone through and those fraudulent letters were sent. It would have made the scheme more dangerous, but it would not have changed the crime.
And how do we think about things like conversations with the vice president? In other words, things that if you say it that way, it's clear that they would fall under executive privilege, but how does that relate to the question that we're asking here?
So this is one of the most difficult questions for the Department of Justice, and I want to explain why that is. If we are operating under a Fitzgerald versus Nixon lens and looking at this the way that we look at things when there is a private lawsuit filed against the president, we take a very broad view of what the outer perimeter of official presidential action is in order to be as protective of the president against private lawsuits that, as this court explained in Nixon versus Fitzgerald, can be very deleterious to the president's conduct of business. So if we were putting this under a Fitzgerald lens, we would then have to answer to the question, was he acting in the capacity as office seeker, or was he acting in the capacity as office holder? And if you run through the indictment, you can find support for those two characterizations, and the Department of Justice has not yet had to come to grips with how we would analyze that set of interactions.
Thank you.